I have the privilege of introducing a special guest on this channel. His name is Rick Friedman. And for those that don't know Rick, he's an author to some of the best books available for lawyers. For example, he wrote The Rules of the Road, Polarizing the Case, The Elements of Trial, my personal favorite, The Way of the Trial Lawyer, and more. But what's even more outstanding is Rick's background. He started out as a solo lawyer, no personnel, in a small town in Alaska. And using the techniques that he provides in his books, he's been able over the years to obtain over $400 million in jury verdicts. So I'm excited to say that this is episode 1 of 6. Yes, this is a 6-episode series where Rick is going to share some of his best information and techniques that have led to him having success. That way you can take your legal career to the next level. And the best part is that some of the topics that he talks about aren't even mentioned in his books. So you're going to want to pay attention. And throughout this 6-episode series, as we talk about specific resources like Rick's books, I'll be sure to provide links to those resources in the description down below for you to check out. Last but not least, if you want to be notified on who's going to be the next person interviewed so you can potentially ask them questions, then you need to be on Law Venture's email list. Simply go to lawventure.com, and at the very top, you can sign up for the email list, because whenever the person is selected to be interviewed, or persons, I'll send out a mass email, and you'll have the opportunity to respond to that email with questions that may be asked during the interview. You're not going to have that opportunity unless you're on the email list, so be sure to check that out. Again, lawventure.com. Now, with all that said, I hope you enjoy the interview with Rick Friedman. All right, I have Rick Friedman with me. Rick, thank you for being here.
You know what, Jarrett? I gotta leave. My pen's not writing. I'll be right back.
I'm here with Rick Friedman. Rick, thank you for being here with us.
Happy to be here, Jarrett.
And I think I told you whenever we had you booked in order to come on the channel, I sent a mass email to all the Law Venture community members. And not only did I get a lot of questions to ask you, but what I got more so than that was the excitement for you to be on the channel. And so this is something I've been looking forward to, and without a doubt, something I know the Law Venture community's been looking forward to. So with all that said, I think let's just dive in. Let's just get into the nitty gritty. Are you ready?
Yeah, absolutely.
So let's start by talking about your book, The Elements of Trial. I have that back behind me. And it starts off by saying, lawyers can always improve their trial skills. Looking back on your career, what improvements have been the biggest catalyst to your success?
Well, early in my career, I had a first-degree murder trial to defend, and one of the witnesses against my client was a jailhouse snitch, someone who was his cellmate. He had also been a snitch in a prior murder trial that was tried by someone who would become my good friend, Jim McComas. So Jim had already tried a case involving that same witness. I got the transcript, and it was like a crash course in cross-examination, because I got to see one of the best maybe the best cross-examiner I've ever seen on paper doing his cross. And so in terms of skill, that was probably the single biggest, teaching lesson. And then, but I think beyond, you're asking about techniques or trial skills, which I get, but, I had a ton of self-consciousness as a trial lawyer in the early years, say the first 30. So, so about 5 years in, I had kind of an epiphany, which was, I'm not that important to the jury. I had this idea that every little movement I made carried enormous weight, and every word choice I made carried enormous weight. And it suddenly occurred to me how arrogant that was. Like, you don't really think of shy people as arrogant people, but there's a certain arrogance and shyness or self-consciousness. Like, everything I do is so important that, the slightest miscue and everything will come crashing down. And I just realized jurors don't really care that much. It's a paradox. In one sense, we are the most important person in the courtroom because we are directing this play, this presentation, and we get a lot of control or at least influence as to what happens. But on the other hand, the jurors don't care where I went to law school or how many kids I have or that I own a Labrador Retriever, which I don't. But, whatever issue we try to like suck up to the jury with, they really don't care. And really all they're looking for is somebody to give them the tools to reach the right decision. And they really just, are you a reliable person to give me those tools or not? That was hugely freeing. That was, I think, really that point in time is when I actually started to learn to develop into a trial lawyer. So.
And was that a aha moment to where you just made that realization, or did that take a lot of work in order to be able to come to terms with something like that?
Well, the work was feeling miserable every time I did a trial. So, so there were a lot of trials under my belt after 5 years. So, but on the other hand, I wish I could say, an apple dropped from the sky or something. It wasn't anything like that. I think I was just ruminating about this is so hard. And I'm, 5 years in and I'm still can't. And then I'm sure some juror said something somewhere after a trial. I'm sure something triggered it, but I have no recollection of what it was.
That's interesting. So you were getting a lot of trial experience. It sounds pretty early on.
Yeah. Those were the old days. And even then people were bemoaning how fewer trials there were. But this is like the early 80s. And, but certainly, I was in a small town in Alaska. Everybody tried, there are 13 lawyers in this town. Everybody tried cases. That's just, little crappy, nothing cases, big cases. It just was part of the ebb and flow of life. Yeah.
So here on Law Venture, we're big proponents when it comes to the story winning the case or putting the case in the best position to win. And I noticed reading your Elements of Trial book, chapter 1, sentence 1 is in a trial, you're trying to tell a story. So from your perspective and based on your experience, how important is the story to a client's case?
Did I really start that off that way?
Exactly. Yeah.
Oh, yeah. Because I really don't like the term story.
Interesting.
So
Okay.
yeah. So there it is in my book. But, I don't like that term because it, in common language, a story often is fictional. It's so, I mean, I understand how people use it and I don't criticize them for using it, but it's not the way I think about it. I don't think about it as a story. I prefer teacher, I'm going to teach people. Now, of course, there is a story.
Yeah, how important is that to trial? And it sounds like maybe pivoting a little bit, how important is it to have the ability to clearly teach that story or teach the events that occurred?
Yeah, I mean, well, so I kind of have a joke to myself that the answer to any question in a CLE is it depends, because it all does depend. And jurors like to be entertained, but the person who's most entertaining doesn't necessarily win the case. They also want to do the right thing. So another place I think I'm going to deviate from a lot of people, but again, we do these sessions where we talk about anything. How do you develop your story? Whatever the question is. Well, it's all very case and context dependent. Has the defendant admitted liability? Have they not? Is it a tough liability case? Is the defendant a little old lady on her way home from church? Is the defendant Monsanto Corporation that's poisoned millions of people? So I don't think there is one answer to that kind of question. What I will say is it's necessary to care about our clients and want
Mm,
to in some way tell their story, but mostly in civil cases, and it's different in criminal in many situations, but in civil cases, it's the defendant's story I want to tell, not the plaintiff's story.
okay.
This is, and maybe that's a function of the kind of cases I've done in the
Yeah,
last
yeah.
20 or so years. Very different if you're telling the little old lady story or the Monsanto story as the
Hmm.
defendant. But if there is a way to tell a story about the defendant first and make that primary, that is, in my experience, a more powerful way to reach the jurors. So let me give you an example. When I started practicing, Trial Magazine, CLEs, all the big trial lawyers would talk about starting the opening statement with the client and their damages. If you
Mm-hmm.
go to this street in Birchwood, Alaska, and drive up the driveway and open the door, in the bed in the living room, you'll see somebody staring at the ceiling. She can't move. She can't talk. That's how they start the case. And the belief was, well, if the jury loves and identifies with our clients, they will go with us with the verdict.
Hmm.
I don't know if that was actually ever true, but certainly I don't think now it's true. I think, and again, it all depends on the
Yeah,
case,
yeah.
but there've been social science study after study, and you may be familiar with this. A couple of people from AAJ actually did a study on this. So I'm going to shorten it up to make the point in the
Hmm.
interest of time, but if you tell the story this way, John Smith skipped school. He was 17 years old. He went to the bar. They served him a lot of drinks. He got in his car. He drove, ran a red light, and hit Mr. Smith or Mr. Jones, uh, and killed him or caused this terrible injury. If you tell the story that way, as opposed to uh, John Jones is an accountant. It
Yeah.
was his wife's anniversary or their anniversary. He was driving home from work. He left a little earlier from work today because he was going to stop and get flowers for his wife. He goes through the intersection, gets hit. You then ask the jurors or the focus group people, finish the sentence, if only.
Hmm.
And if you say, if only in the first version, they'll say, if only the bartender hadn't served him the drinks. If only,
Hmm.
on the other hand, if you tell it the second way, it's if only it hadn't been his anniversary, if only he hadn't left early from work. So jurors, all of us start to put responsibility for causation on whoever or whatever they hear about first. And
Interesting.
playwrights know this. Apparently, I mean, I've never studied this part, but I've read about, if it's a mystery play, jurors tend to blame, or audience members tend to suspect the first person they see on the stage as being the person who did. So now, if you have an admitted liability case with a little old lady who's,
Hmm.
has a moment of inattention and she rear ends somebody and causes whiplash injuries, uh, I still think you start that way. But so I don't know how satisfactory these answers are, but I think,
No, this
um,
is great.
yeah.
So doing law venture and creating law venture content has actually been a great researching tool for me as a lawyer. It's been really interesting because I've had to learn in order to cater to an online audience on like what is going to grab attention, what is going to keep attention, and I can test different things out. And one thing that I've learned is that a headline, and this isn't going to be, profound. I think whenever I say it, it's going to be like, yeah, of course. But a headline that's negative tends to get more focused than a headline
Right,
that's positive. I feel
right.
like that's pretty parallel with what you're saying, to where like let's talk
That's
about
right.
everything that went wrong, and then
Sure.
boom, you have the attention from the get go. But
Right.
I've been taught the opposite way that you're saying of like, hey, like here's our little old lady client. Let's talk about her and everything she's done.
Yeah. Yeah. In terms of if she's the injured one, you mean?
Yeah, yes, exactly.
Yeah. Yeah, absolutely. And it's tempting, we get to know our clients, we feel for that, kind of the more empathetic you are,
Mm-hmm.
the more you want to talk about how badly your client's life has been disrupted. But the very first thing in the jurors' minds, they're judging both sides immediately.
Yeah.
Who's right and who's wrong here?
Mm-hmm.
And the fact that you're a nice person who got injured doesn't tell me anything about who's right and who's wrong here. The
Mm-hmm.
fact that you're in a coma or whatever doesn't tell me anything about who's right and who's wrong. So that judging begins instantaneously. And the sooner you can start, as a plaintiff lawyer,
Mm-hmm.
showing the jury who's right and who's wrong, the sooner they start, even if they don't want to, unconsciously at least taking sides.
So is your approach when developing the story throughout trial? Because I've heard of lawyers that say, okay, as soon as you put that first witness on the stand as the plaintiff's lawyer, the jury's primed to be critical of someone. Is your approach to put, either the defendant on the stand or a witness that isn't going to be favorable for your side in order to just come in heavy?
Absolutely. I mean,
Okay.
and again, it depends.
Yeah. Yeah.
If I've got a bad acting, a medical malpractice case, I'll
Mm-hmm.
frequently put the defendant doctor on first. In a corporate case, I'll frequently put the 30B6, the corporate
Mm-hmm.
representative on first. Not always. The other thing, that's one approach.
Yeah.
The other approach I'll often do is put on a witness who can talk about how bad the defendant was.
Mm-hmm.
So, like when I started trying insurance bad faith cases, for example, one of the accepted approaches, many very successful plaintiff lawyers would put the insurance expert on last. The idea was he's heard all the bad stuff and now he's going to deliver. I almost always put the expert on first
Mm-hmm.
so that he or she can turn their sights on, okay, let me tell you what Mutual of Omaha did in this case.
Yeah.
Here's how
Yeah.
insurance is supposed to work, and then here's what they did. So, but yes, I try to put the spotlight on the defendant right away if there's any way to do that.
So how do you, with this type of strategy, prevent a race to the bottom, so to speak, to where the defense comes in and then just starts criticizing your client? At what point is there posturing of building up your client?
Well, I mean, there is a race to that's what a trial is a race to the bottom. And that's, the way you phrase it.
Yeah.
Um, well, I mean, we have opening statement. And
Mm-hmm.
so I do build up my client in opening statement. But in opening statement, I talk first almost always. I can't even think of an exception except criminal cases. But in civil
Mm-hmm.
cases, I always talk about the defendant first or the industry or the
Yeah.
overarching
Mm-hmm.
thing. And if it's an admitted liability, I'll start the opening statement with, as we've already talked about, everybody agrees that Mrs. Defendant is 100% responsible for what happened to Jane Smith. No doubt about that. And they're 100% at fault. So we're not going to talk about the accident. The judge won't permit that because they have 100% liability,
Mm-hmm.
responsibility. And what they did to this woman is, and then I'll start talking about she was a 42-year-old mother of three, et
Yeah.
cetera, et cetera. So certainly I'll build up the client. I don't mean to say that's not very important. And
Mm-hmm.
likable clients get more money than unlikable clients usually.
Mm-hmm.
So all of that is important. But I think a lot of lawyers get so wrapped up in their client story, they forget that really what the juror's trying to do is not figure out, is this person injured and how bad? Even in an admitted liability case, they're
Mm-hmm.
first trying to, who can I trust? Who's going to tell it to me straight? Who's being reasonable and honorable? I'll even use that word, and who's
Yeah.
not. Yeah.
And you're referring to who can I trust as the attorney or who can I trust as the client or the the party?
Both, like,
Okay.
yeah, but all like,
Mm-hmm.
and this is more and more true as the cases get more and more complex, because is a juror ever really going to understand the PhD level chemistry, or the neurosurgery that went on, and
Mm-hmm.
that some of them will, and some of them are actually, in my view, evaluating who can I trust. It's like if you had I don't know, Stephen Hawking's and Albert Einstein in front of you debating the nature of black holes.
Yeah.
And they had diametrically opposed positions.
Yeah.
How much of that debate would you and I actually understand? And so we'd be making judgments about, well, who seems to be telling the truth? I mean, we do that all the time in our daily lives. We see a commercial for two different cars. Which car,
Yeah.
that we are human, I don't want to say lie detectors, but like credibility judgers
Mm-hmm.
all the time. Who am I safe to go with, and who am I not safe to go with?
And that's another aspect, I guess, that we do subconsciously because we get ads all the time, right? Like, is this product going to be good? We get content all the time. Is this content going to be good? We hear about like fake news and things like that. So we're always judging and trying to figure out, like you said, like who to believe in. I like that approach. It is different than what I was taught, which I guess makes me wonder, are you reaching these strategies just from your own experience and trying different things out and seeing what comes out to be more productive? Or do you have your own content and research and other aspects that you're going down as a way to learn and hone in your craft?
Well, it's all that. I mean, it's all of
Yeah.
that. I've been, for the first 30 plus years of my practice, I just read everything I could find on trial practice and
Mm-hmm.
sorting through it, some is better than others.
Yeah.
And although many of the people who put their ideas out there kind of have almost a fundamentalist attitude, you have to do it this way or it won't
Mm-hmm.
work, or you have to do, as I sorted through that material, and then of course had my own trials and tried things out, I began to realize there's not a single formula for any of this. And
Yeah.
so partly it's my own experience, seeing what works and what doesn't work. Part of it's what I read. Part of it's watching other people and what seems to work for them. So it's all of that. If you can really get to that place where it's not about you, it's way more fun. It's way more effective, and paradoxically, you increase in stature.